first point of investigation starts where?
I will start the investigation with the person that gave the complaint.
That's the thing. You read it while the person is there. If it's assigned to, normally they get it, they will assign it to the investigating police officer, the IPO. The IPO invites the complainant. You say that this blah 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 happened. That's when they take statement of the complainant. At the point that the statement of the complainant is being taken, that's why the investigation starts. Right. The police, if he is smart enough, can ask reasonable questions. And if in the end he's not convinced that any crime has been committed, he can jettison the complaint. Knowing fully well that anything he does outside that will mean what? Violation of somebody's fundamental rights. So the act of investigation starts from the complaint or the petition submitted by the complainant. And then after that, the police may also be obligated to ask the complainant who witnessed this. And then bring in the witnesses, take their statement. If in the end there's need to visit maybe the scene of crime, the police can also visit the scene of crime. Make sure that the police is already armed with enough evidence before even doing what? Inviting the suspect. But it's a different thing if the suspect is somebody who can easily escape or run away. In that case, the police has to do what? Expedite action, do the more they can in the interim, and then apprehend the person. But that kind of apprehension entails that once that person is apprehended, the person must be interviewed immediately. And if nothing is found, nothing stops the police from saying, okay, we're investigating an allegation against you. Don't leave town until we are done. You have your freedom, you can move in, but don't leave town until we are done with the investigation. So that one will not be a violation. It will not be a violation of the person's fundamental rights. So that's talking about the police now. Then there are other similar agencies that also have powers to arrest and investigate crimes within the purview of the authority given to them statutorily. For instance, we have the ICPC, the Independent Corrupt Practices Commission. Their business is to investigate what? Corrupt practices. So they can arrest based on all these grounds that we have already enumerated. For instance, where somebody is suspected reasonably to have committed an offense, or where the person is caught in the very act, or where the offense has been committed in the past, or where there is a complaint bordering on corrupt practices. So this body has the right to do what? To arrest and follow the same procedure, because all these things, they are act of what? Policing. So they will follow the same procedure expected of the police. Not you arrest the person, collect bail money, and then when you are satisfied that he has brought enough money, you then release him. That would be a violation. Because when somebody challenges his arrest, what the judge should be interested in knowing is the reason for the arrest. His own, as an applicant in an action for fundamental right, is to complain. My rights have been violated, this is what happened, underscoring the reasons. Then the arresting body will say, no, he's lying, this is not the true position, this is actually the true position. They will present their own position through their counter affidavit. So if my lord, looking at the evidence before him, is satisfied that there was justifiable reason for the arrest, then there won't be anything like violation. The court will not rule that the arresting officer has violated the rights of the applicant. Of course, we also have that of the EFCC. But the most important thing we need to note here is that each of these bodies are confined to their areas. It's not like maybe when you're having problem with your neighbor, because you have a brother, a friend who is an EFCC officer, but you report a matter to EFCC. No. So their own is to investigate what? EFCC, financial crime. If you're owing your landlord, is it a financial crime? So, not because the tenant is owing you, you report the tenant to EFCC. So, that won't work. And then again, we also want to talk about private persons like you and I. So we have this power, we have these rights. We can arrest, and that's why most of the times in some communities, they organize vigilante group. But the thing is that once you apprehend somebody based on all these reasons, you should be able to do what? Surrender the person to the appropriate authority. Surrender the person to the police. Not to make your own punishment on the person and take the laws into your hands. That would be wrong. So because by the time we deal with the next topic, we may not repeat all these things again, we'll now capture them. And then we have talked about who should be arrested. A suspect, somebody who has committed crime, and that suspicion against him must be what? Must be reasonable. The suspicion against him must be reasonable. And now, talking about suspicion, let me ask you this question. If somebody is caught running away from the scene of the crime, is that suspicion reasonable or unreasonable?
Running away from the scene of the crime does not necessarily mean that the person committed the offense. By raise reasonable suspicion, the person could be running away out of fear or panic or fear of being wrongly accused.
I like all the answers, but make them objective. So you now see that in law, our answers are not like the mathematical thing, 1 + 1 2. No, it's evaluative. Right. This person who was seen running away from the scene of crime. General rule is that the mere fact that somebody is seen running away from the scene of crime does not mean that he has committed an offense. That's the general rule. And to every general rule, there may be an exception. All right. Now, does it stop him from being invited for questioning? No. It does not. Right. Because the police is not a spirit. You understand? The police are not spirits, they are human beings. So there is no way they will know the mindset of that person who was running away and they were apprehended. But the point is that treat him right. So ask him questions, find out why were you running away. It could be, well, he was really bad. Just like you say, he was afraid, or maybe he's a resident in the house, so he ran out of fear, he wanted to get help. Anything could have been the case. That's where the wisdom in investigation comes in, because you actually need to know. Now, what if, for instance, as he was running, other people were pursuing him before he was apprehended? Would the answer be different?
Yes.
So why would the answer be different?
It would be reasonable to say that he committed a crime, because if he did not, he wouldn't be running away, and he also wouldn't be chased by. Okay,
Sorry. Any other contrary view? Any contrary view?
Sir, I think that the same measure we apply to the first one should be applied to this too, because
What measure?
the main thing there is the fact that people are chasing him does not really indicate that he committed the crime. Because like someone will run away from a crime scene, from being afraid of being arrested. That's the way he can be running away from those people, because as an act of shock, so he doesn't want to be left out by the people, just want to run away. So the event is that get the person, interview him. So his testimony from that onward not determined.
So it's purely a probability that he might have committed an offense or he didn't commit offense. But there is this reasonable suspicion. People are pursuing him. So it's a reasonable suspicion. Because one, you don't have the answer. I'm talking that the person arrested now doesn't have the answer. But he's saying if this person did not commit anything, they will not be pursuing him. So it's better to do what grant him first. Right. So that act of arrest has two implications. Okay, now the first implication is that What if they wanted to mob him for doing nothing wrong? That arrest becomes what? Protective. For which he could even be put into protective custody. Right. Now, the arresting body, you've seen somebody being pursued, you grab him. You also need to do what? Gather some of those people who are pursuing him to find out what did he do. Why were you pursuing him? It could also be that those people were acting based on suspicion. Maybe they saw him carrying jerry can, and maybe he was looking for where to buy fuel. And upon seeing the houses, the money, you know there are some people who call Abaranya. You just stay there and was watching. And the people say, this man is carrying jerry can, and then immediately he saw that people were around, he started. You understand? You know, if you were in Aba during the heat time of kidnapping, and then, you know, you see a vehicle, maybe a vehicle is just coming behind you, the exhaust blows. And one funny thing is that once you see somebody running, you don't even want to know why the person is running. Right, so that is what we are trying to underscore, the meaning of reasonable suspicion. So reasonable suspicion depends on what? The circumstance of any given case. So it's not like when you see it in the exam scenario, you just tell me there's reasonable suspicion. You have to tell me why the suspicion is reasonable. If you feel it's unreasonable, you also have to tell me why it is what? Unreasonable. And then you have case laws that are related to this. You do what? You cite them. Then for the rights of the suspect. Now, if the suspect is being arrested with a warrant, you'll be entitled to be shown the warrant. You show him the warrant of arrest and introduce yourself. You know, I'm a police officer, and a complaint has made against you. I have a warrant, this to apprehend you. And then the person will now be satisfied that he's dealing with a police officer. Not that a police officer just see and grab your trouser and started pulling you, and you're shouting, who are you? Show me your ID card. Show me your wallet. Does it happen?
Yes.
It happens. It happens because these officers failed to do their duty. They failed to accord the suspect the right under the law. If you have shown the suspect your ID card, introduce yourself, and you also show the suspect the warrant of arrest, there won't be any need to ask you. Do you understand? And by the way, what is a warrant of arrest? Warrant of arrest is just like a process, a document, containing the order of a court, either a magistrate or a judge, commanding that such a person be arrested and brought before the court. So that is what warrant is all about. I will know that we also have instances where somebody can be arrested without a warrant. Now, after the arrest, the next thing is what? If we just so don't say, follow me to the station. And they say, what did I do? So when you reach there, we will tell you. You know, that is their pattern. Yes. They will tell you, you know when you get there. That is very, very wrong. You, first of all, as a arresting police officer, after these preliminary requirements from you, you now tell the person the information concerning his arrest. You know, while you are arresting him, the complaint, they say you stole a fowl. They told you ate somebody's egg, you ate somebody's bread, blah, 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 whatever it is. And you have to say, why are you laughing? Did he eat your bread? And you have to give this information as an arresting officer in the language that the suspect does what? Now, God bless you, the suspect doesn't understand the English. And the question is that, are you permitted to hold him while you look for an interpreter? Because assuming you are just telling that the person is speaking Fube or just speaking Hausa language to you, and then you know that, okay, our Hausa is not very far, and maybe if I leave him now, he will run away. What do you do? What do you do?
I just said, if there's reasonable suspicion or a likelihood of escape, the person escaping from within that environment, you can just hold the person.
All right. So that's the answer. You don't need, as an arresting officer, you don't need to, put him under fetters or even hold his hand. The only thing you're allowed to do is to tap him to draw his attention, and then you give him the information. And then you say, okay, you're speaking outside, follow me. Let's go and look for your brother to interpret it. You understand? As at that time, you're just being a gentleman policeman. So, but if you attempt to run, you now invoke another power given to you under the law. Are you following me? Why? Because the arresting police officer has a right to use reasonable force. We also talk about that later. But where it is unnecessary, you don't bother. And if, for instance, maybe the person you are arresting speaks your language, nothing stops you from doing what? Informing him. And look at what they said there you did. But when you take him to the station, you must get what? An interpreter. The fact that he hears your language and the arresting officer, you don't take it for granted. I say, okay, he said in Igbo language and I translated in the English language. The major point I'm making here now is the arresting officer, to be safer, get another interpreter who will, after writing, introduce himself and then, if possible, swear, that he is a sworn interpreter who interpreted it at the police station. So that when he gets to court, you're also going to subpoena him to come to court and now speak under oath that he was actually the person who did the interpretation. Because if you don't, it now becomes a violation of his rights. That he didn't hear what you say. In other words, there was no fair hearing. Or he didn't even hear at all. That's the meaning. So no fair hearing. Okay, and then this right to remain silent is another right. The arresting officer will tell the suspect, you have the right to remain silent because everything you tell me now will be recorded against you and will be taken as evidence against you in the court of right. Then again, there should be no violence against the suspect. So you shouldn't just use force against him. As an arresting police officer, you are enjoined not to in any manner violate the dignity of the person, the human person, of the suspect. Why? Because the law presumes him what? Until the contrary is proved. So he's still an innocent person, even if you caught him stealing. Just like Haliches will tell you, if you want to lie, tell a scientific lie. You could end up convincing the jury. You could even tell them that, yes, I was caught with my hand down deep into the soup pot because I didn't see spoon, I was stirring it. Except if the soup is not hot. Why should you use your hand to stir the soup? So that's it. And then cancer, that's why we had a little misunderstanding with the group. So when she talked about representation, it goes with the right to remain silent. The right to remain silent simply means it's not perpetual, it's not forever. You understand? It's in the interim. What is it subject to is dependent upon my getting a legal representation. I'm not going to talk until my lawyer, and that's at times you see people are ready to say, can I come make a call, can I call? They say, they seize your phone. It's wrong to do that. It's wrong to do that. They don't, except if the phone is part of the exhibit, part of what you're suspecting that might have been used in commission of the crime. You see, like in this modern world, a lot of crime can be committed also through the aid of phone. Right, so you remain silent until your lawyer comes or you get a lawyer. Now, there is no right that you must be given a legal aid, no. It's a different thing when it is during trial. If you are being tried for committing a capital offense and you don't have a lawyer, That's when the judge will make an order for you to have a legal representation. And in that wise, it has happened to me a couple of times. A judge will see me, and say, okay, this person doesn't have a lawyer, take the file. It's pro bono, whether you like it or not. And then again, they can call the legal aid people. The next one is when you get to the police station, or when as an arresting officer, the suspect is taken to the police station, he must be shown the complaint against him. If there's a dispute by way of petition, show him the petition. If he can't read it, then he can call his lawyer. So that is a right that must be acknowledged. Then, let me say finally, the arraignment, after all these things, the arresting officer must make sure that this person is not being detained more than 24 hours. You have to get that. Thank God that most police stations are not very far from the court, right? But when you don't have a court within a particular radius, then you are allowed to take 2 days, 48 hours to arraign the person. So when you don't arraign the person, then detention is what? A violation. Most of the time, when you see a suit against the police for unlawful arrest and unlawful detention, they will tell you we didn't detain him. We invited him. Once you invited the person and he comes, you have done what? You've arrested him. And once a person, a suspect is in your custody, you have done what? You have detained him. Why? Because once in your custody, he can't move. He can't go out. Do you understand? Until you are done, until you grant him bail. So it flies in the face for any police officer to tell you, I merely invited him. I didn't detain him. Once he's in your custody, the fact that you have detained him does not make your detention unlawful. Are you following me? If the reason is what? Justifiable. The reason is the primary thing to look out for them. And then again, we mentioned reasonable force. Police can use reasonable force to compel arrest. Can't tell me maybe three policemen went to arrest one person and then you batter him. The person breathing eye is swollen and they say this which reasonable force? Which reasonable force? Why don't you tie him and take him to the police station? Alright, so far so good. Let's see if we have the next group.